Hi, I'm Brian Smith, a partner in the Trust and Estates practice group at Moore Ingram Johnson Steele. In our practice area, we help clients formulate an efficient and orderly plan for the distribution of their assets during life or at death. We do this by putting many different documents in place for the client. These documents include wills, trusts, powers of attorney, healthcare directives, and any number of other documents that may help the clients meet their objectives. When I meet with a new client, there's three issues that I like to focus on. The first issue are the client's personal objectives. This is what the client wants to do in their will. I figure if I can't accomplish the client's personal objectives, then it's not really worth exploring the other issues that are important to them. The second issue that I like to focus on are state probate laws. Every state has a different probate system. Here in Georgia, we're fortunate. Our probate system is very user-friendly. That's not the case in other jurisdictions around the country. In our planning, we try to make sure that regardless of where the client owned assets at the time of their death, the administration of their estate is efficient. We do this by using trust and other documents that may help facilitate the administration in those difficult jurisdictions. The third issue that we focus on is federal estate tax laws. Each of the attorneys in our practice group are well versed in the intricacies of the Internal Revenue Code, specifically the federal estate tax and gift tax. While these issues don't arise in every estate plan, they are issues that need to be addressed in many and will help minimize the estate tax bite felt by the beneficiaries upon the parent's death. A recent hot topic that's come up in my practice area involves powers of attorney. Powers of attorneys are documents through which we're able to give someone else the power to make our business and financial decisions for us if we're incapacitated or just generally unavailable. Problems with powers of attorney, though, are that they're not completely enforceable. Many times you'll find banks and other financial institutions who refuse to accept powers of attorney. This is not just a problem in Georgia, it's become a problem nationwide. On July 1st of 2017, the Georgia legislature enacted House Bill 221, also known as the Uniform Power of Attorney Act. This act had two goals. First, to create a more enforceable document that could be used in the state of Georgia. Second, to protect the principal against any sort of misuse by their agent. They did this by creating a statutory form and told us that if we use the statutory form or a form substantially similar to that form, then our documents would be more enforceable when presented to banks and financial institutions, and that our agents would also be more accountable to their principals. While documents created before July 1st are still valid in the state of Georgia, it's a good idea for all people with powers of attorney to consider taking another look at their documents. With an aging population and an increasing rate of dementia-related illnesses, powers of attorney are more important than ever. I encourage everyone to pull out their powers of attorney and take another look at them in light of this new change in the law. If you have any questions regarding estate planning or powers of attorney, feel free to call me at any time.